Three. Hello, everyone. This is Attorney Lin Wang in Trust and Wills. And today we have Karen over here. Karen, would you please say hi to our audience, please? Thank you.
Hi, my name is Karen O'Brien. I'm a real estate broker in Massachusetts. And I get questions often about wills and trusts and people trying to buy a house in probate and not understanding what is going on. So Lynn is going to explain what a will, trust, probate is, especially when it has to do with someone who's passed away and selling property.
Yes, I'm ready to answer your questions. Thank you.
So I find families are confused. Grandmother passes away, they read the will, and they decide to put the house on the market because it's supposed to be split. And they go ahead and do that, but they do not have permission from the courts. So the government oversees when someone passes away, they have to review a will. So can you explain what happens when someone passes away? What's the first thing a family needs to do?
If you have a will, or if you don't have anything, you don't have a will, you don't have a trust, then you need to go to the probate. And the probate will figure out whether the will is authentic or not, or who gets what. For example, whether you have surviving spouse, surviving children, if not, whether you have surviving parents, surviving siblings, like nieces, nephews, like level by level. So in this way, they will try to figure out who gets what. And it will take some time to figure the whole process. Usually, they take you 1 to 2 years to finish the whole process. They will charge you 5 to 15% of the money. Like if you have $1 million, if we pass away, we need to pay 50K to 150K. And
who do you pay this to? Excuse me. Who do you pay this to?
You pay it to the court, to the lawyer. They need to go to the probate court. The court charges you, the lawyers charges you. Yes.
Okay, now that's if you don't have a will or you do have a will.
No matter whether you have a will or not, you go to the probate court process. Even if you have a will, you need to go to the probate court. So they will verify whether your will is authentic or not. Because if you have a will, you don't record it anywhere, like when you're still alive. So if you pass away, you have to go to the court. And the court will verify whether your will is authentic or not. So it can take time.
Okay, now say grandma has a will, it's authentic. They even know the lawyer who did the will for her. The first thing a family should do is call that lawyer, and the lawyer is the one who presents the will to the probate court.
No, not necessarily. There is executor in the will. That is usually the families and friends designated by the deceased person to execute the will, to distribute the assets according to the will rules to the beneficiaries. So that is the person who needs to go to the probate court, not the lawyer. The lawyer only helps you to draft the document.
Okay. So the person who's named in the will as the executor goes and files probate.
Correct. And if they don't know what to do, they can turn to lawyers, but not necessarily the lawyers who have drafted the will documents.
Okay.
They only draft the documents for you. If you need to go to probate court, that is another case. And usually it takes you the 1 to 2 years to finish the whole process. And also it will disclose your privacy information to the public. So the public can have access to your will, to your personal information. So if they have any objections, they can file it to the court.
Okay.
So it is time consuming, very risky, and very expensive.
Okay, so I bring the will to probate, file probate. And by exposing your private information, you mean you have to post an ad in a local paper explaining the deceased in the will, and if anyone contests this, then speak up. That's basically what happens. Nothing can be done until it's a public that this person has passed away and the will is in probate. Okay, so say I want to sell the house, empty the house, sell it according to the will. And then there are other things like, say, there's some investments and everything, but you would like permission to get a piece of paper that says, I can sell the house right away while everything else is being figured out. Can you ask the judge for that?
Yes, after you go to the probate court and before the judge has the final decision whether you can distribute the assets according to the will rules, if the court is confident that your families don't have arguments about whether to sell the house, perhaps they will give you the permission, no guarantee, but perhaps they will give you the permission to sell the house before you are allowed to disburse the money. So you need to take the court order to sell the house. And if the court thinks perhaps you still have some arguments about whether to sell the house or not, the court can refuse to give you the order, so you cannot sell the house before everything is done.
Okay. And so whether or not it gets, say it gets sold, that money can't go anywhere until probate closes, correct?
Correct. You have to wait for the whole probate court process to be closed before you are allowed to disburse the money. Before that, the money is in a third-party escrow account. No one can touch it.
Okay. An escrow account is like when you buy a house, your deposit goes into an escrow account that can't be touched by either party. So the same thing happens here. Say the house is 500,000 or 900,000, that money goes into the escrow account and sits there until probate gets resolved.
Correct.
So generally, a lot of people do that. They have a will. They don't realize that you have to go through probate to verify all this. What is the benefit of having a trust instead of a will or in addition to a will?
If you have a trust, you don't have to have a will, because when you have a trust, like a will, you will state who gets what in your documents in the trust. But at the same time, if you only have a will, it's only a black and white paper, and you don't record any assets in the name of the will. But when you have a trust, you need to record the assets in the name of the trust. For example, if you have a house, you need to record the house deed in the name of the trust. If you have a bank account, if you have a life insurance policy, you need to name the trust as the beneficiaries of the bank accounts, the life insurance policies. And in this way, if we pass away, we don't have to, like the will, to go to the probate court to verify whether it is authentic or not, but we can go to the places where we have assets directly because we have recorded our trust in the name of the assets. So they know that is authentic document because we record them when we're still alive. So we can recover the money directly. Of course, we will designate trustees in the trust. For example, our surviving spouse, our surviving children, so they will have the authority to do that immediately after our passing away. So they don't have to go to the probate court process. So there is no 1 to 2 years to wait time. There is no privacy disclosure. There is no the waste of the 5 to 15% of the money. They can recover the money immediately. So I would say a trust is definitely a much better way than a will to distribute the assets after our passing away.
What if I pass away and I have one house and my assets are 1.5 million? How would a trust benefit me?
If I have a trust, I record the house in the trust. If I pass away, I don't go to the probate. I don't wait for 1 to 2 years to finish the process. I
So-
don't need to.
So I name my trustee. So I'm the trustee until I pass away, and then it will have someone else. And that could be a relative, it could be a lawyer, it could be a friend, becomes my trustee. What do they do? Do they have to walk into a lawyer's office with the trust in hand? Or do they read it? They need someone to explain what the next step is. How does that work?
The trust is an authorization paper. It authorizes the trustees to take over the assets immediately and automatically after the trust creator passes away. So they don't have to go to a court. They don't have to go to a lawyer. They just use the trust and distribute the assets directly according to the trust rules. So they go to the places where they have assets and they just recover the assets immediately. They don't need to turn to anyone else.
And do they have to prove anything? So say on my bank accounts, the trustee can walk into the bank and cash out all my bank accounts just by showing the trust and signature and verifying an identity. Is
They
that how?
only need to show the trust documents and the ID of the trustee to prove their identity.
That is very smooth.
Very direct.
Yes. Okay, and so I wouldn't need a will if I spelled everything out in the trust.
No, you don't need to have a will. If you have a will, you don't record your assets under the name of the trust. You go to the probate after you're passing away. You take 5 to 15% of the money. You take 1 to 2 years for waiting. You waste your privacy. If you have a trust, you can do everything without a will. You don't have to go to the probate. You save time, money, and privacy.
So can I put all my furnishings and my car and all that into my trust and say,
You can put everything in the United States in the trust, no matter whether it is a house, it is automobile, your bank accounts, your brokerage accounts. It cannot take assets from other states, from other countries, but if it is in the United States, you can put everything in the trust.
wow, this is really good. Say I have an investment accounts and they're like a Roth IRA or a traditional IRA. That wouldn't be in the trust because there's a named beneficiary on each account. Is that correct?
Actually, you can even put your retirement accounts in the trust. You can change the beneficiary as the trust, and you will get extra benefits from that. Because if you only name beneficiaries as individuals, for example, your children, if they have creditors, if they owe money to others, or if they get divorced, the creditors and divorce can take the money away from your children. But if we put it in the trust can protect your children against their creditors and spouse, so they get extra protection. You can change your beneficiaries as the trust.
You're selling me on putting everything in a trust.
You can do that. Actually, that does give you a lot of benefits.
That's good. Are there any drawbacks to having a trust?
There is no drawback for having a trust. Because
so they're called revocable, meaning I can revoke anything in that trust. But if it's irrevocable, it's locked in forever.
If it's revocable trust, it means you can still use everything when you're still alive. And if you pass away, you give the assets to your families without probate. So that's very convenient. And you even can use revocable trust to protect against your beneficiaries, creditors, and spouse. So the money will stay in the trust even when you pass away. So your children will enjoy the assets without the interference of their creditors and spouse. And if it is irrevocable trust, you give up the rights to your families when you are still alive. So in this way, you can protect against your creditors. It's not like the money will be in the trust forever. No one can use it. No, that's not the case. Just you cannot use the assets. You can ask other people, for example, your children, to use the assets. In this way, you can protect against your own creditors. So you can decide whether you want to exchange the benefits to use the assets for the benefits that your creditors cannot sue you for the assets, so that you can balance the pros and cons.
Very nice. So I often get people questioning me. They have a will. They're, say a family member passed away. They have the will. The will names the executor. What are the steps? If they want to sell the house, they need the executor to be appointed and get a piece of paper before they can actually sell that house. Is that correct?
Correct. Like we have discussed, they need to go to the probate. The probate needs to verify the will is authentic instead of, like there is inappropriate thing happening over there. And then the executors need to take the paper from the court. We call it a court order to be the executor. They cannot be executors automatically. They have to get the approval of the court first.
So if this takes a long time, the family has to pay the property taxes, make sure the house is secure, maintain that property. Could be 6 months or a year until they have permission to sell.
Correct. So that's why I suggest people to have a trust instead, because they already record the assets under the name of the trust when they are still alive. So it's impossible that the trust is not authentic, because otherwise they will not record the trust when they are still alive. So in this way, they don't have to go through the probate. They don't have to wait for the time. They can sell the house immediately if their families pass away.
So I think I vote for a trust. I know prices range. Wills are not that expensive. A trust might be a little more expensive, but in the long run, it probably saves time and money.
Correct. Like for our will, it is $950. And for trust, it can be $3,000 or beyond. But if you have $60,000 when you pass away, you go to the probate. Let's just be optimistic. Like there is not a lot of argument in your family. The court only charge you 5% instead of 15%. 5% of $60,000 is $3,000, let alone the time and privacy wasted in the court. So if you have assets beyond $60,000 left behind, you should consider a trust.
That 60,000, is that just a number, or do you think that really makes, if you should consider a trust if your assets are higher?
I think if you have anything beyond $60,000 left behind after passing away, trust is your must.
Okay, great. This is great information. I think a lot of people, especially people who have lost a loved one and they're like, what do I do? They know the steps they have to take. If they think about themselves, it's like, I don't want to have to put my family through probate, the will, and all that. I think I'll create a trust. Everything will be named in that. I'll name a trustee, and you can also name more than one trustee. So say you have 2 children, they're the trustees, so they make the decisions and sign the paperwork. It seems a lot more civilized.
Correct. If you have rules, for example, you cannot sell the houses, your trustees follow your rules. Otherwise, your trustees can negotiate with each other to decide how to work on your assets. Yes.
Very good. Very good. Well, thank you so much, Lynn. This has really helped, and hopefully it'll help our viewers to understand a little bit more about wills, trusts, probate, and the things you need to do to plan and make your life and your loved one's life so much easier.
Absolutely. Thank you very much, Karen, and thank you for watching this video. Thank you. Bye. Have a good day.
Have a great day.